Article 2 of GDPR, which is material scope. First point of Article 2 states that this regulation applies to the processing of personal data wholly or partially by automated means and to the processing other than by automated means of personal data which form part of a filing system or are intended to form part of a filing system. The second point states that General Data Protection Regulation or GDPR does not apply to the processing of personal data in the course of an activity which falls outside the scope of union law by the member states when carrying out activities which fall within the scope of Chapter 2 of Title V of the TEU by a natural person in the course of a purely personal or household activity by competent authorities for the purposes of the prevention, investigation, detection or prosecution of criminal offences or the execution of criminal penalties, including the safeguarding against the prevention of threats to public security. The second point states that for the processing of personal data by the union institutions, bodies, offices and agencies, Regulation EC number 45/2001 applies. Regulation EC number 45/2001 and the other union legal acts applicable to such processing of personal data shall be adapted to the principles and rules of this regulation in accordance with Article 98. The third point of Article 2 states that this regulation shall be without prejudice to the application of Directive 2000/31/EC, in particular of the liability rules of intermediary service providers in Articles 12 to 15 of the Directive.